Hello guys, welcome to our channel Know the Law, and here I am advocate Jyoti Charadia. And yes guys, before starting with our today's lecture, please do subscribe our channel, and yes, don't forget to press the bell icon which will keep you updated about our upcoming videos. So yes, guys, today's our topic is Article 14 of the Constitution, which speaks about the equality. And equality is not only contained in Article 14, but it contains from Article 14 to 18. But today in our lecture, we are specifically going to deal with our Article 14, and later on in our upcoming videos, we will watch what is written in Article 15, 16, 17, 18, and so on. So let's get started with our today's topic, in which we will deal with why the Article 14 was inserted. Supreme Court of India went on extending or widening the scope of Article 14, and how the rights of the people, especially of the citizen, and not only the citizens are included, but the companies, foreign peoples who are non-residentials of Indian, their rights are also protected. So let us study in detail one by one. So basically, after gaining independence, even after 75 years, the our country is not able to gain the actual independence from the evil of discrimination which are still prevailing in our country. And not only this, but the creator of the constitution, that is Dr. Baba Sahib Ambedkar, also face the evil of race discrimination, caste discrimination, and whatnot. But nevertheless, the constitution begins with the preamble, and preamble is like a framework in which the constitution has to be set up. It's like a what we can say, the trailer of the constitution, the output of the constitution, what will be contained in the constitution, everything is in short mentioned in the preamble. And in the preamble itself, uh, states that the constitution promises the equality of status and opportunity, that is mentioned from Article 14 to 18. So India is highly diverse country, be it the religion, be it the language, be it the culture, be it the traditions and whatnot. Not only the culturally, socially, but economically as well. And it is essential to have the fundamental right to ensure everyone is treated equally for that purpose. So, right to equality is regarded as a fundamental element that is necessary for implementing those rights which are guaranteed to the Indian citizen. It lays a foundation for all the rights and privileges of the Constitution. So, this is what the introduction was. So now we'll see what is the rule of law says about the same. As we the Constitution of India much was influenced by various countries, various constitution prevailing in the world, but mainly we were influenced by the England's rule of law. So one of the highly recognized, what we can say is, the author or the commentator or the professor, the Dicey, had given the concept of the rule of law. What does the rule of means? Rule of law means that no person is above the law. Equality of law is part of the rule of law, which has been explained by the Dicey among in the following 3 points. First is the supremacy of law, second is the equality before the law, and third is constitution originates from the ordinary law. And what we did in India is the first and the second rule has been adopted. But the third rule, which says that the constitution originates from the ordinary rule of law, does not been accepted in India, because in India the constitution is regarded as the supreme law of land, and the rights of the people originates from the constitution itself, and all the other laws which are passed by the legislature should not violate the provisions of the constitution. So basically in India the constitution is the other general laws. So we haven't accepted the third rule, but first two rules have been accepted very clearly. So further going to the article, straightforwardly to Article 14 of the Indian Constitution. So what does the Article 14 rates all about? So first let's read out the Article 14 and then we will understand what does exactly it means. Article 14 Article 14 says that equality before law. The state shall not within the territory of India. Here, the word, the citizen, the non residentials, the residentials of India, these are all not used in the article. That means the article is not applicable, not only applicable to the Indian citizen but also applicable to the NRIs as well. And not only this, here the word any person is used. Any person means the it includes even the companies, even the whatever the definitions accepted by various uh, laws, it includes all that, be it legal person, be it the natural person, be it the person created by the parliament, whatsoever. So everyone enjoys the equality before the law, no matter he is legal, he is natural person, he is man-made person, whatsoever. So for our better understanding, we will divide the article into equality before the law and equal protection of laws. So first we will understand the equality before the law. Under equality before the law, the principle of like should be treated alike is followed. That means the person who are at, in the equal circumstances, who are having the equal amount of opportunity enjoyed, to them person the law should be of the same kind. But to the person who haven't enjoyed the equal opportunity, or is of not the very backward class, he is disabled person, to such people the discrimination should be there so that the equality can be served. That is the main purpose of this Article 14. The equality before law is originated from the English law, and it is a very negative concept. Negative concept in the sense that it means that right to sue and be sued on the same cause of action should be the same for the people who are equals. That is, the people who are in similar circumstances, and such right should be available to them without any discrimination on the basis of religion, sex, caste, or any other such factor. Just few seconds earlier, what I have explained, the same goes on. So that is why it is regarded as a negative concept. There are ways to the same equality before the law. So what are the exceptions to this? We'll study one by one. There are first one is Article 361. Article 361 we will study in detail later on in our upcoming videos, but he will say the overlook of that Article 361. It says that the President of India and the state government shall enjoy certain immunities, like no criminal proceeding will be followed against them. They will be not answerable to the court. The police cannot or the court cannot order the arrest warrants against them, and so on. And same goes with the Article 361A. No person shall go through a civil or the criminal proceedings with the aspect to report published in the newspaper related to any proceedings of an parliament. That means any member of the parliament or any member of the this legislature uh, who had spoken something in the parliament, and on that basis the article has been in newspaper, and on that basis no proceedings can be held against such legislature or the parliament member. That is the meaning of 361A. Next, coming to article 105, which saves the member of parliament from the court proceedings for giving a vote in the parliament. That means if a member of parliament or a legislature gives a vote for and against for and against any bill or any person, he cannot be proceeded for the same, because he enjoys that much of privileges being the member. Next is Article 194, which protects the member of the legislature against anything said in the legislature. As we have seen earlier in the 361A, same goes with the legislature. Article 31C, whatever the also enjoy the privilege or exception under Article 14, and as it is related to directive principle of state policy, it enjoy the exemption. Again, the foreign sovereigns, yes, this is also important. The foreign sovereigns or the diplomats or the ambassadors, whoever come from the different countries to visit India for any purpose, be it the political, be it the meetings, or for future funding to the country or making with the country, such people cannot be proceeded, because against them the laws are prepared at the international level, so they can be sued at the international level, not in the country India. So same as the diplomats, the united organization also enjoys the same privileges. Now coming to the next part, second part of the article, that is the equal protection of law. What does it says, we have to study in detail. So the concept of equal protection of laws has been borrowed from the American Constitution, and it is a very positive concept, as is similar in the 14th. That means whatever the have been stated in the American Constitution has been detailedly copied from them and stated in our Constitution under Article 14. Equal protection of law does not postulate equal treatment of all persons without distinction. What it postulates is the application of same laws alike without discrimination to all persons similarly situated. It denotes equality of treatment in equal circumstances. It implies that among equals, the law should be equal and equally administered, and the like should be treated alike without distinction of race, religion, wealth, status, or political influence. Thus, the rule is that the like should be treated alike and not that unlike should be treated unlike. So, basically, overall, we have studied so far. The main aim of the Article 14 is that the person who has got the equal number of opportunities, or like who is physically the same, who is physically not disabled and who had got various opportunities and of the same caste, same religion, these all persons should be treated equally. And the person who is from the backward class, who is from like unprivileged class, who is disabled person, who are not got that much of opportunity like any other person usually gets, such person should not be treated equally. So the laws for both the circumstances should be different so that the equality and the justice can be prevailed. So further goes the reasonable classification. Reasonable classification is based on that only, the how the distinction between the two can be made, and what are the rules for that, how what are the conditions of that. Let us study in detail. Which case it was stated, we'll see that. So it was in the state of West Bengal versus Anwar Ali Sarkar in 1952. The Supreme Court laid down the doctrine of reasonable classification, which is as follows. So let's read out what is stated by the Honorable Supreme Court while laying down the doctrine. The classification is made on the reasonable basis. The legislature can deal with the states of individual. Reasonable classification must be based on smart differences. Furthermore, this classification basis must have a rational nexus to the object legislation is seeking to achieve. For example, the law of maternity benefits applies to women working on the way to maternity and not to others, because the purpose of the law on maternity benefit is to grant privileges is to grant the privileges only to the women who turn out to be a mother when they need them. So the category of men and women is based totally on the intelligible differentia. So from this illustration we can understand what is meant by the reasonable classification. So reasonable classification here beautifully explained by the way of law of maternity, which is where a class of a woman is classified from the other class of women who is going to be become a mother, and she need her child will need her from time to time to for the basics need of the life to survive. So for those women the maternity leave is very essential. So for that purpose the maternity leave is very helpful, and not, and it will be a justifiable, and it will serve as equality to them. And whereas the unnecessary the leave by other class of women will not serve as the justice. This is what meant actually by the equality before the law and equal protection of laws. So further going upon a class of persons, class legislation makes improper discrimination by selecting a large number of persons arbitrarily. No reasonable or substantial differences can be found in justifying the exclusion of one and the inclusion of the other from such privileges. So from this reading we can understand that the reasonable classification is allowed under Article 14, but the class legislation it is very much violated by the Supreme Court of India. Even the arbitrary classification is also opposed by the Supreme Court. So the classification to be reasonable, the two conditions must be fulfilled. First of all, the classification must be found on the intelligible differentia. Intelligible differentia, which distinguishes persons or the things that are grouped together from the other sets that are left out. Secondly, the differences have a rational relation to the object that has to be sought to be achieved by the act. Similarly, that the maternity act or the law sets to achieve that the child would need a natural survival. So that is the mindset of the legislature to be achieved. If it is applicable to the other women's or the men's, then the purpose of the law would not be achieved. So the main purpose of application of the law should be achieved if they are giving classifying the people for that purpose. And the classification should be such that it should be a reasonable, which can be understood by even a layman, essential for that purpose. So the doctrine of arbitrariness was coined by the constitutional bench of the Supreme Court of India in the case of E.P. Royappa versus State of Tamil Nadu in 1974. It is a very prominent case where Article 14 was further interpreted and widened the scope was given to it. The arbitrariness occurs when the classification is made without any specific and the legs are not treated alike. If Article 14 makes classification arbitrarily, then it would amount to discriminatory in nature, which proves to go against the very nature of the Constitution. So the arbitrariness and the class legislation is very totally opposed by the Supreme Court and as well as the Constitution of India. So this was all about the explanation of Article 14, the exceptions to the Article 14, the doctrine of reasonable classification, what are the conditions for it, and so on. So now here we will study the prominent landmark judgments which were passed by the Honorable Supreme Court of India from to time, and which have widened the scope of the Article 14 to the highest level. So let's see them one by one. First is the Charanjit Lal Chaudhary versus Union of India of 1951. The court in its judgment held that not only individuals but the companies can also come to the court under Article 32 of the Constitution, as these companies also has the protection under the fundamental rights. So as I said in the very starting that any person is used, so the legal person is also considered as a person under this article. So next case is of the Indira Swani versus Union of India 1993, when the constitutional case for the reservation in India, it is a very prominent case and which cannot be neglected. In this case, the bench, while delivering the judgment, interpreted the relationship between Article 14 and Article 16. The case recognized the right to equality as a basic feature of the Constitution, and the court held that the Article 14 applies to the person and is not restricted only to the citizens of the country. That means it will apply to every person, be it the NRI, be it the diplomats, be it the legal person, be it the natural person and the resident of the country. It will not create any differentiation of the classification among the person as such. So it will be applicable to all and every person. And not only this, The Article 14, 19, and 21 is regarded as a golden triangle without which the existence of a human being in any country is very impossible. We have seen Article 14. Later on in our upcoming videos, we will see what is Article 19 and even what is Article 21. So basically, for today's purpose, only keep in it mind that Article 14, 19, and 21 is regarded as the golden triangle. So what is meant by golden triangle? We will study in I will study Article 21 in detail. So next case is of the Magan Lal Chagan Lal versus Municipal Corporation of Greater Bombay. So in this case, which was much needed, the Article 14 to the Constitution, because by delivering the judgment in this case, the Supreme Court provided the much needed clarification to the reasonable class. In this case, clear distinction between the statute which make a classification themselves and those statute which make a classification which is authorized by the executive. So here are the two components. One is the classification is made by the statute itself, and second situation is that where the parliament gives the power itself in the statute to the executives to make the classification. So in case where the classification is made by the statute itself, uh, the statute will be held invalid if it fails to meet the reasonable classification test. That means if the classification itself made by the statute, then if that goes against the constitution, or that provision goes against the constitution of India, then it will be regarded as unconstitutional the whole of the act. Whereas the classification is made by the executives, uh, and the executive makes such classification and it fails the test of the reasonable classification, then the only the action which has been taken by the executive will be regarded as invalid and not the statute. So clearly understand that the whereas the classification is made by the executive, then the action of the executive will be held invalid and not the statute. So that was the basic and the main classification to uh, the test of the reasonable classification. So this is all about the prominent cases. You can study the Nargesh Mirza case, again these Article 377 case, the transgenders case, even the Sabria Bano case, Shaira Bano's case, again the Sabria Malla temple case, again the Shani Shignapur temple case. These are various cases from time to time the Supreme Court have tested the in its scope. To that extent, even the gender discrimination, even the class discrimination, even the every kind of discrimination was stricken out from by the Supreme Court from time to time. So thank you very much for patiently listening to my lecture, and if you have any kind of queries relating to any of the articles studied till today, from starting from how the constitution was made very first came to into existence, and from article 1 to 14, if you have any doubt, please do comment in our chat box. We will surely come out to wait for explanation to it. And yes, please don't forget to subscribe our channel. uh, and yes, forward this, uh, share with this with your friends, relatives, so that they can also understand whatever the constitution says about what are their rights and much more. So keep watching, keep sharing, and see you in the next video. Thank you. Bye bye.